And good morning, everyone. Welcome again to the NSDCAR Chit Chat. This is version number 7, actually. We started this 7 weeks ago, and it's been really well received. You're in for a special treat today. We have with us Jana Gardner, who's counsel at CAR. You may have spoken to her when you called in the hotline, and if not, you're going to, again, she's going to be a special treat today. We're going to talk a lot about the new forms. She'll be here to answer questions. Just a little heads up how this is going to work today. You're not going to get the whole typical Zoom experience with the whole Brady Bunch boxes. With 200 people expected, that's a little bit overwhelming. So the way we're going to do it is you're going to see Jana's picture up on the screen, hear her presentation. And if you would like to participate, we're going to use the chat box. Don't need to raise your hand. Just make sure you use the chat box. Those questions will be passed on to Jana throughout the presentation. May not get to every one of them. Again, with a couple hundred people expected, it might be difficult, but a lot of the questions seem to be the same. So I'm sure Jana will get to it, and we'll be here pretty much as long as we need today. So if you're not familiar with how this is going to work, if you're using a PC or a laptop, if you scroll your mouse down to the bottom, hold it down there, you should be able to see the chat box. Click on that and type it in. That question will come to the panelists. If you're using an iPad, up in the right-hand corner, there should be the 3 little dots there. Click on that. You'll be able to chat with us there. So again, don't raise your hand. Make sure you use the chat box and we'll get those questions answered for you. So without further ado, let me introduce again Jana Gardner, who is counsel for CAR. It's all yours, Jana.
Good morning, everyone. Happy to be here with you today. Like Chris said, I'm Jana. I'm an attorney with CAR. I've been with CAR for about 6 years now, just over 6 years. So hopefully I've had a chance to speak with many of you either on the legal hotline or at an outreach like this, if you ever attend business meetings. But I'm glad to be here today. Nice to get to check in with everyone and give you a little update about what's happening with the standard forms, with the most recent new statewide showing guidelines, some DRE updates, and just other CAR resources that hopefully you are aware of. But if not, I want to make sure you know all of the information and resources that are available to you. So I am going to share my screen here so we can see. Hopefully that works and you guys can see my screen now. Excellent. And we will jump right in with our information. So the first thing that I want to direct everybody to is the COVID legal docs and resources page. I have the instructions on here on how you get there. It's car.org, Transaction Center Risk Management, and then it's the top link, Coronavirus Legal Documents and Useful Materials. This is the legal landing page for all COVID-related information. There's obviously also the CAR-wide microsite, carcovidupdates.org. Definitely recommend checking that out every day for the latest news updates. But whenever you have questions about the forms, the webinars, any of our guidance materials we've put out, we're putting everything in this one place. So pretty much everything I'm going to be talking about today, when you want to go back and take a look at it for yourself, can be found right here. So one quick piece of breaking news that just came out yesterday before I get into the forms. You probably saw DRE for any of you who might have soon-to-be agents who are planning on taking their exams or anyone who is planning on taking their broker's exam. Originally, the DRE had postponed all exams through today, basically, through the end of this week. Well, now they've extended it until the end of this month. So as of right now, all scheduled real estate exams through the end of May have been canceled, and you can go online to reschedule. They're not charging anybody, but that's the latest update in case anybody was planning on taking a broker's exam or had anyone who was planning on taking their agent's license exam. Not happening in May. Hopefully will be rescheduled, or they will find some way to make these happen sooner rather than later. But now I want to talk about the new forms. So we've been getting a lot of questions from people about, what are all the COVID related forms? How do I find them? They are all in zip form. And for the most part, if you go into zip form and just type the word coronavirus, that's in the title of most, if not all, of the new forms. but we've also made a easy way to just find them for sure, which is when you are in zip form inside the CAR library, you may not have known, maybe you did, I learned recently, that you can pull up forms by category, and we have created a COVID-19 category. So if you want to go into zip form and you're worried about scrolling through and missing something, you can go to the category button, choose COVID-19, and that's where you will find our complete list of all the new COVID-related forms that are available, which has gotten up to 9 coronavirus-related forms, 4 for purchase and sale transactions, 5 for property management, landlord, tenant. So it is a lot, but they are all in there, and that's where you can find them. So let's talk a little bit more about the contents of these forms. The 2 most recently updated of the COVID-related forms are the CVA and the PED form. The CVA you're probably familiar with because it was the very first form that came out pretty much immediately. Like the week that we all went home, the CVA form was created to try to address the pressing issues relating to transactions. So we're on, I think, version 5 of it by now, but it's being updated for clarity. One of the most important things that's been happening as part of this process is the forms committee and the attorneys have been working as hard as they can to get forms out quickly, but then to also revise them and update them as we get feedback from the field, from agents and brokers about what is working and what is not. And so that's why you see these forms getting revised. I think they're in a really good place right now, but every time I come on one of these meetings and tell people that the forms aren't going to be updated, they immediately get updated. So just keep that in mind, that there are continuing to be tweaks and updates, both based on member feedback and also based on the fact that the rules and the laws keep changing, which we're going to talk about in just a second. But on a weekly, if not daily basis, there's new guidance from the state and there's new rules about showings and transactions. And so we just have to do our best to stay current with that. So the first form I wanted to talk about was the CVA. And the updates to that were really mostly clarity based. There was some confusion about how this form was used and when. So the main changes this time around was that there was a paragraph added to make it very clear when the notice of unforeseen circumstances was being attached along with the form. And then the other main revision is that there's 2 options in the CVA the parties can agree to. They can agree that either immediately or in the event of unforeseen circumstances, that there will be an extension of time, either for contingencies to be removed or for the transaction to close. You can say, here's a problem I'm having, I need more time, let's extend. Or you can agree in advance, we hope nothing goes wrong, but if something does, I'm going to give you the notice of unforeseen circumstances, and then we're going to extend the time periods. Or the parties can use the form essentially as a way to immediately mutually cancel the contract. And so that is one of the key changes that was made, separating out, you have 2 options. You have options for extending, or you can choose right now to mutually agree to part ways, depending on the needs of the parties in the transaction. It gives the parties options to extend. The default is for all contingencies to be extended in the event of unforeseen circumstances, but you can choose loan only or any individual contingency. And then it also clarifies for extensions that the time periods are going to be extended from the date of the notice of unforeseen circumstances for contingencies. But if you're asking for an extension for the close of escrow, it's going to be extended from the original close of escrow date. So let's take a quick look at that form. So this is what I was talking about here. Paragraph 3B gives you an option to attach the notice of unforeseen circumstances. So there's basically 2 ways to use this, right? You can use the CVA if you're already in contract and something has come up, somebody has fallen ill, someone's been laid off, there's an issue with relocating. You can use this form as an amendment to an existing contract together with the notice of unforeseen circumstances to tell the other party, here's what's happened and here's what we'd like to do, and basically propose an extension or a cancellation once you're already in contract. Or The other way it can be used is as an addendum to an original offer at the time you enter into contract, to basically say, if something happens, we want to have the right to get this extra time to extend. There's a lot of people right now who maybe things are still going more or less okay, but they feel like the situation is precarious, and they want to have the option to say, you know, if something comes up, if I or a family member gets ill, or if all of a sudden my job disappears, I want to have these rights to have more time and try to resolve the situation. And so that's the other way it can be used. In that case, you would give the CVA by itself at the beginning, and then later on deliver the notice of unforeseen circumstances when the time comes. And then finally, like I said, it can be used as a form of immediate mutual cancellation if the parties have decided that the transaction just can't move forward and it needs to cancel due to whatever's going on with everyone, and it can be used to cancel that way. All right, so that's the CVA. And then the next form I wanted to talk about that was most recently updated is everyone's favorite form, the PEAD form, the PEAD, Property Entry Advisory and Declaration. This form, I always tell people that if you are going to use a single COVID-related form in your transaction, this is the one you're going to use. Because, you know, maybe you have clients who aren't worried about unforeseen circumstances. It's cash. They're not worried about it. You know, they might not have any concerns about the terms of the transaction, but the PEAD, now more than ever, is not optional. This is a form that needs to be signed by everyone who is an occupant of a property, every seller of a property, and every person who enters a property every time they enter it. So a couple quick notes on the most recent updates to it. One is that not only are the signers making representations about their current condition, they're representing that to the best of their knowledge, they are not ill and have not been exposed to anyone who is ill. Now they specifically also promise that if that situation changes, they will notify the broker and update them if something happens and they do become ill. Paragraph 8 now was created. It has exemptions to the representation. Some of the feedback we were getting was that certain people, most notably healthcare providers who might be looking to sell or buy a home, can't sign a form saying that to the best of their knowledge they haven't been exposed. You know, they might know they have been or have no way of knowing whether they have been or not. And so we did get some feedback asking, you know, well, what are they supposed to do then? They can't sign this, that would be lying. So now there are some options on there. If your client has been ill or has been exposed or has reason to believe they have, it doesn't mean that they are, you know, necessarily out of the situation, but they at least can provide that information to the parties and everyone can be on the same page about what's happening with everyone's health and safety. And then a couple of clarifications were added. There was some original confusion about how and when this form should be used. Some language was added to say that you can use one PEAD form each date that you enter the property. And we added a third signature line so that potentially buyers and their agent or broker could sign on the same form. So let's take a quick look at the PEAD form. All right. So a couple things at the top here. You'll see there's some instructional bold language right under the title where it says that a new declaration must be obtained from each visitor each time they enter the property. And gotten a fair amount of pushback from people about this. I know it's a lot of paperwork. I know it's burdensome on you and your clients to have to sign a form every time you go in. But the reason for that is the fact that the person is making a representation. They are saying, I am healthy, I haven't been exposed, I'm going to follow these rules. They need to make those representations each time they enter the property. So it does have to be provided. There is also a note that it can be used for more than one property if more than one property is visited on the same day. I was getting calls on the hotline, and I think a lot of my colleagues were too, from people who were saying that some agents were filling out the PEAD and just saying, this form is to be used for all properties in California in 2020 or something like that, and thinking they could just have their client sign it one time and give it to everybody. And again, not the case. You can use it for more than one property in the same day, but the properties still need to be identified on that property addresses line at the top. And you can't use the same form on more than one day. The day they sign it and provide it is all. And again, it's for risk management purposes. It's to protect all the parties involved, but it's also to protect you. As a broker, as an agent, you want to make sure that you are taking all the steps possible to protect the health and safety of yourself, your clients, your community. So that really is the way to do it. Again, when I get the complaints from people about how burdensome this is, one of the things I'm reminding people is that as much as people are eager to get back out and about and doing their business, it's not business as usual, even where things are open and things are moving. So, I've talked to people who say, well, this is a lot of paperwork. I want to take a family of 8 through 25 properties this weekend. And my response is, well, that's not exactly what is supposed to be happening right now. The idea is that virtual showings are still supposed to be the preferred way of showing properties, and that in-person showings should only be for situations where virtual showings just aren't possible, or for extremely serious buyers, people who are pre-qualified, people who've done a virtual showing, and they think that they either have written a contingent offer or they think they are ready to. Then by all means, do a safe showing, have the PED form signed, but still no open houses, right? Still not parading people through properties constantly. So just keep that in mind. Like I said, the form is very important. And then as it comes to the signatures down here, you can see that there's options for, it should be signed by anybody coming through the property. So that might be the buyer, the broker or agent accompanying the buyer. There's also a spot there for other entrant, because this also should be signed and provided by anyone who comes through. So inspectors, appraisers, contractors, any other person who is coming through the property, they should be signing this form and providing the same representations and information as everybody else. And then finally, there is a section down here to acknowledge receipt of it. And that can and should be initialed by the broker or agent representing the buyer or the seller, and then the seller initialing that they received a copy as well. So again, extremely important, probably the most important form, definitely the form we get the most questions about, and the form that is most constantly evolving. And I am going to talk a little bit about why in just a second. The only other couple of forms I wanted to go over very briefly with you. One is for listings. The coronavirus, oh, that's not for listings. That's
Hey, Jenna.
Yes,
Jenna,
go ahead.
before you come, we do have some questions in there we'd like to get to.
Yeah, absolutely.
First, a comment. That last part about broker or agent, that's new. When the
Yes.
form was first revised or came out, it was just broker. So that just for everybody to be aware of that. But again, we're having the questions about vacant homes. Does it need to be used on vacant homes?
Absolutely. Great question. Thank you for asking. Yeah, this applies to vacant homes too. I know that when it comes to vacant homes, I mean, it's preferable, it's better, it's safer for everybody, but the rules are the same for vacant properties as well. This is not just for occupied properties. You should still be having the seller as the property owner sign a PEAD, and you should still be obtaining a PEAD from everyone who comes through the property. One question I've had from people about that is, well, if it's a vacant property, how do I enforce this? Well, what a lot of people are doing is setting it up so that no one can access the property sort of fully on their own. Maybe you have a code enabled lockbox on the property, and the buyer's agent doesn't get the code to access until they've sent you the PEAD. Or if you don't have a lockbox, then you go over and you don't open the property for anyone until they provided you with the PEAD. But the same rules do apply as far as getting the form and following the rules that it lays out. Absolutely.
Okay. We have some back on the CVA, but we'll get back to that. It says PED 6C seems to say nobody will enter the property unless wearing a mask gloves, booties. Is that correct? What if not all those items are available?
That is correct. And, not only does it say this in the PEAD form as a best practice, but as I'm going to talk about in a second here, that's essentially what the state has said as well, as far as guidelines go. The masks, at least, are pretty much non-negotiable at this point. Anyone who is out and engaging in in-person, face-to-face interactions with people, the masks are not optional. And, a lot of people, as I'm sure you're all more than aware, have been making their own masks at home. It's really a face covering. It's not like you need to go out and get a medical mask, but if you have a bandana or a scarf or something, a face covering does need to be worn for face-to-face interactions. The masks and booties are definitely best practice, and strongly encouraged. And the gloves, especially, are, again, strongly encouraged. Booties, I know, are not as common, and then there's also certain safety risks with those depending on the nature of the property. If the gloves aren't available, then and I'll talk about this too, hand sanitizer needs to be made available to people, and hand washing is supposed to take place pretty much every time anyone enters a property as well.
Okay, so obviously everybody that enters a property, so the agents can't just sign on behalf of buyers or sellers. The buyers and sellers have to sign.
Yep.
And does the seller have to acknowledge receipt of the P before the buyer enters the property?
They don't have to. The listing agent is legally able to sort of receive it on their behalf. It's really for your file. You would want to get it to the seller and have them initial it. That's something that, as a listing agent, I would have that conversation with your seller about their comfort level before you let someone into the property. What is the seller's expectation? Are they comfortable with just you having it, or do they say, I want to see it before someone comes in? That is I think, procedure that could be established between a listing agent and a seller.
Okay, and electronic signatures on those, fine?
Totally fine, yeah.
Good. Another question I heard in a marketing session, someone having an open house, no more than 2 people in at a time, is that allowed?
No, not really. I've also heard of some people calling it an open house, but really what they're doing is scheduling windows for showings, which, at a certain point, the definition of open house gets a little bit fuzzy. If you're scheduling people to come in at certain time windows, then really it's just back-to-back scheduled showings. But an open house, as you traditionally think of it, where people just show up, is still no. You can't do it. It's not advised. It's not allowed, especially because, as I'm about to show you, the state has issued some guidelines that says properties are supposed to be cleaned between every showing. So, you can allow 2 people at a time. They can leave. Someone can go in and clean and wipe down the entire property, and then the next person can come in. But again, that's not an open house. That's just you're scheduling showings. And I would say, if you are scheduling a series of showings in a day, you want them spaced out enough so that people don't cross paths unnecessarily, and you have that time to clean the property between each showing. But really, no form of open house is happening, not yet.
Okay, hey guys, everybody out there, we're getting dozens of questions, so we're trying to get to them as best we can, and then we have to make sure that you can go on our presentation. So a couple of things that I wanted to mention. One question about booties. Booties can be slippery. I know that in standard forms, we have a form coming out in next month talking about that. Exactly.
Mm-hmm. Yeah, that's sort of one of my concerns also. I think like I said, of all the health and safety advice, I consider the booties sort of the ones that, depending on everybody's comfort level. If you're showing a property that has, let's say, stairs that are hardwood floors, I wouldn't be comfortable with people going up and down those in slippery booties. There is a sort of weighing of the risks there. I admit I would have to go back and double check. I don't believe the state showing guidelines mandate booties. Those are just an extra level of precaution. It's the masks and gloves that are much, much more important.
Okay, and then the question about acknowledging. I fill out the form for my buyer, I go and I send it to the other agent, and they don't acknowledge it. What do we do?
Mm-hmm. I would say that if you fill out the form for the buyer and you send it to the other agent, if they then let you access the property, you've done what you're supposed to do. As with all forms that you're sending, sometimes it can be like pulling teeth to get the other agent to confirm any acknowledgement of receipt. So as usual, keep track of your own records, save that email where you sent it and when you sent it, to show that you did provide it. But at a certain point, it's the listing agent is the one who should be making, most importantly, sure that they received this form before they allowed you to access the property. If you get it signed by your client and you sent it over, you've done your job. That's sort of the most you can do in that situation.
Okay, I know you've got to jump on. I know there's lots of questions in here still, but maybe we get to some of those later, because you're going to answer some of these I know that are coming up already with the following.
Sure. So. All right. Okay, cool. Yeah, thanks guys. I know it's a lot. It is, and I'm going to go through the next couple of forms, I hope very quickly, and I'm sure there'll be some questions there as well, but I really just want to highlight one more form on the sales side and then talk a couple of landlord tenant forms. And then I'll get to the new showing guidelines and checklists and things like that. So the next form that I wanted to talk about was the listing agreement addendum or amendment. And so this form, again, not required, but highly, highly encouraged. Basically, what this form does is it lets you set boundaries with your seller client from the very beginning of a listing, and lets them say what they are or not comfortable with, advises them of the various risks and potential impact of listing a property right now, and if they do opt to limit access in any way. And it also says in big bold letters that basically, although brokers and agents are supposed to and almost always do follow instructions from their clients, brokers and agents will not be doing anything that violates any laws. So if, for example, you do have a seller who wants to insist that you hold a big open house this weekend, this form lets them know that you are going to be obligated to follow the state and local laws that apply. And even if they want you to do something, you may have to say no based on the rules that are in place. So I think it's good to have for that reason. It defaults to the seller allowing showings with certain rules in place, although it does give them the option to opt out of in-person showings if they're not comfortable with that. It limits showings by default to anyone who's provided a copy of the PED form, but it also gives the seller the option to further limit access to the property to people who are pre-qualified or provided proof of funds, and or to people who confirm they've already shown the property virtually. And again, I think these are great ideas. They're really part of our best practices anyway, but it's a conversation to have with your seller about access and showings and their comfort level. It then also advises them about what kind of access to the property may be required for both marketing activities and for the transaction itself, letting them know or reminding them people are going to come in for inspections. People are going to come in, you might end up needing to get fumigated. There may be movers coming in and out, and just really making sure the seller has thought through how much traffic there may be through the property. It gives them the option of opting out of it, but at the same time, it advises them that if they limit access to the property, one, that can affect the value of the property and the listing agent's ability to sell it. And two, if they want to limit a buyer's access during the transaction, that would require major modifications to the purchase agreement, and it advises them to get legal advice and if they're going to want to craft something specific based on those desires. And the final option on here is if you have, and the good news is, I will say, we're seeing less and less of this as time goes on, but for a while we were having a lot of sellers who wanted to take a step back and temporarily withdraw the property from the market just until everything settled down. If you do have a seller who still feels that way, there is an option on this form to temporarily withdraw the property from the market. So, like I said, this goes along. You can add it to an existing listing. It's also a very good form to include with any new listings that you take in the near future here. All right, and then just two more forms I wanted to touch on about landlord-tenant issues. As you are all probably aware, there is basically an eviction moratorium statewide at the moment, as well as a lot of local specific eviction and rent rules depending on the individual city where every property is located. But essentially, for the months of April and May statewide, if a tenant was not able to pay rent due to coronavirus-related circumstances, either because they were ill and quarantined, or they lost their jobs, or they were home with children, they basically didn't have to pay the rent. The due date was deferred to later in the year, and you can't evict them. So we did get a lot of questions from landlords who just didn't even know how to have this conversation with their tenants. We created this notice to tenant form that basically is just a way of starting that conversation, reaching out to a tenant. Hey, we all know there's a lot of things going on. If you're having trouble paying the rent, please let me know so that we can work something out. We're all in this together. You know, sort of starting a cordial and professional communication with the tenant to that regard. As it stands right now, in the state of California and in most, not all, but most cities and counties, this deferment of rent is set to expire at the end of this month. And it's currently scheduled in many places for rent to be due on June 1st. And then as far as the April and May rent that went unpaid, the tenant does still owe it, and they have a certain amount of time to pay it back, depending on where the property is located. Each city, again, has its own rules. It's basically as little as 3 months, but as many as 6 to 12 months, depending on what the local government has done. And that's where the RPD form comes in, which is basically a repayment plan form. It allows the landlord and a tenant to document very clearly, here's the rent amount, here's how much was paid, maybe it was zero, maybe it was partial, here's how much remains due, and here is how we're going to coordinate the repayment. This form is set up assuming that everything stays the way it is right now, and that starting in June is when rent will begin being repaid again. But there is also language in here making it clear that, you know, if the law changes, ultimately the law is what prevails. So you have a form saying that the tenant's going to start paying rent again in June. Well, if the governor extends the order, then that ultimately is what will control, and a new repayment plan would have to be worked out. But now more than ever is a good time to try to keep relationships with tenants as non-adversarial as possible, because on top of all of these special COVID-related protections, there is also the fact that the Judicial Council of California, which controls all of the courtrooms basically in the state, has just frozen all evictions for the time being. And they plan to leave that freeze in place for at least 90 days after the expiration of this current order. So again, assuming no extensions, judges won't be hearing eviction cases likely through the end of August. So even when rent does become due, if a tenant doesn't pay, there's just not going to be a quick, I mean, there's never a quick or easy way to deal with an eviction process, but it's going to be even lengthier and more complicated than in normal circumstances. So keep that in mind. To the extent it's possible to work something out with a tenant, that's absolutely the best advice I can give anyone in that situation right now. So that was it for forms. Chris, is there anything we wanted to touch on before I move on?
There's a whole bunch of them. The last question on this one, is this just residential or is this commercial property as well for the?
Residential, so the statewide rule is residential as far as not owing rent for April and May. Some cities have expanded it to commercial. And that last part I mentioned, the freeze on unlawful detainers, that's everybody. So that is commercial as well. So essentially, yeah, no evictions, residential or commercial, are going forward in the short term.
Okay, and just as a reminder to everybody, this presentation is being recorded. We have a YouTube channel that we've set up just for NSDCR. So if you just go to nsdcartv.com, you'll be able to see not only this presentation, but the previous 6. And just as a reminder, the first week we had Joel Singer from CAR, Art Carter from CRMLS, and Ernie Dronenberg, who's the county assessor. The next week we had Fred Pfister, county association attorney, talking about forms as well back then. Third week we had Lawrence Yoon, who's the chief economist for NAR. The fourth week we had CRMLS, they were talking about virtual open houses and the clear cooperation policy. Last week we had Brad Inman and obviously Janet today. So all of those recordings will be available there. The notes we're not going to be having these notes. These are your notes, but they can see the whole presentation there. So that's number one. If they're as standard forms, it's normally our policy that we don't modify a form within 2 years of its release. That's a general rule, but obviously that's out the window now. Some of these have been updated multiple times since they've been released in the last month. So the question is, how do we know which form, like the PED, and are we using? Obviously, just the most current one that's in there in the library today.
Mm-hmm. Right. So, I mean, the good news is a couple of things. One, every time you go into zip form, that is the most current version. That's, you know, if you're worried that the one you're looking at is the most current, go into zip form, pull it up. One thing to keep in mind about that is if you've saved the form to an existing transaction, that freezes it. So that's going to be whatever version you pulled. And one thing to be careful of, sometimes I know people like copy over templates and things like that from one transaction to another. That can make you stuck with an old version of the form. So make sure you're pulling up a fresh one from zip form. And then also in terms of just checking revision dates, one thing you may have noticed is typically when you're looking at a form, it says the revision date is, you know, the month and the year, you know, last revised December 2019 or something like that. That was not really working anymore, as Chris knows, because we're updating it multiple times within the same month. So now, for example, if you do pull up the CVA form, and let me get it back over here for you so you can take a look at it.
Yeah, one of them shows 416, one shows 420.
Exactly. And like, for example, here, when you look at the top of the form, you'll see now 4/30/20. Like that's the most recent version is 4/30. So you can actually see the full date on the top of the form. And you can always reference this quick summary that shows the revision date and the date that it replaced. And this quick summary is available back on that COVID legal documents right at the top there if you ever want to look at that comparison chart. And I know the forms committee and the attorneys keep that super up to date every time the forms are revised.
A couple questions back on the CVA if we can. One of them on the cleaning. Lots of questions on cleaning between showings. Who's responsible?
Right.
What degree? Who determines?
Right.
That's obviously.
That is an excellent question. And if I may, it's a CVA form and it's a PED form, but it is also a question about the new COVID industry guidance that just came out this week from the Department of Public Health, because they have made some decisions about what is required in terms of showings and cleaning and things like that. And there are, you can find this industry guidance here this is the web address. It's at the state's website. They have these actually for many industries. So to the extent you may have any personal connection to any other industries, they have a bunch of these that tells you if you're going to be doing business, how it should be done. This is the real estate version. And I will jump here to information about shown properties. Oh, that's not the best slide, but what it says on it is basically that it has to be, that those cleanings have to happen before and after every showing. One piece of good news I can give you is that CAR has been in constant contact with the governor and with the Department of Public Health about this. The initial guidance that they put out last week, it used phrases like disinfectant and sanitation and things that made people extremely, extremely nervous. And it also specifically said that the agents were responsible for the cleaning. And so CAR reached out immediately to the Department of Public Health to say, you know, wait a minute, this is not really feasible. This is not really in line with standard practice in other industries, and it does not really track with how the real estate industry works. And so there has been an update to that. Now, it basically says that the property just needs to be like thoroughly cleaned or deep cleaned. Without a more specific definition, but at least it doesn't say disinfected or sanitized, which would seem to raise a higher standard. And really what it's talking about is high touch surfaces. So doorknobs, countertops, things that people may touch. Now, granted, people are also being advised not to touch anything. When people come through properties, You want to have doors open. You want to have light switches on. You want to limit anybody having to touch things, and you want to tell them not to touch things. But you still want to have these surfaces and everything wiped down. As far as the responsibility, the language was updated to no longer state or really imply that it was an agent responsibility, just that the property should be cleaned. But again, from a practical standpoint, that's going to be a conversation that if you're a listing agent, you're having with your seller about how is this going to work? Are we going to have a service? Is someone going to come in? What is the expectation? Ideally, don't love the idea of agents or brokers taking on that responsibility for cleaning. That's not your profession. That's not what you're an expert in. But it is a conversation to have with a seller about, if we're going to be doing showings, how is this going to be accomplished? What is going to be the most reasonable procedure for everybody to follow? It is, again, it's a very burdensome requirement. And the state feels strongly, apparently, that it's necessary. And so that is where we're at. And again, we're still in the very early days of this. CAR right now, literally as I'm talking to you all, is working as hard as we can with Gov, and my colleague Robert Bloom and some of our other attorneys are putting together a comprehensive package that we hope to have out very early next week that will include updated best practice guidelines and sort of official, policy based on the clarification we've gotten from the state agency. So hopefully by then we'll have a little bit more clarity. We're still having that dialogue with the Department of Public Health, basically. So still figuring it out, unfortunately, is where we're at with a lot of those things.
Another question that I get asked all the time, it's only been asked a couple of times here in the chat box, but you're selling a property that is rented. You've got a tenant in there. A whole nother layer of issues about.
Oh yeah.
Yeah. Can you kind of go over that a little bit?
It is. It's extremely tough. And I will say, I sort of said that the PED form is the number one call I'm getting on the hotline, but dealing with tenants is right up there as well. Because it is very fraught, and it puts everyone in a difficult position. I will say that in most places, and I believe this is true for most of San Diego County at least, it follows the state guidelines, which is you are allowed to show occupied property. You're still limited to how many people can be there. So one, the tenant absolutely needs to be signing a PED form themselves. And ideally they would step out of the property while someone comes in and shows it, either to a yard or to maybe go to their car or just somewhere outdoors, to allow for maximum space. In some places, for example, here in the city of Los Angeles, where I am, the way the showing rules are here, you actually have to get express written consent from the tenant to show the property. So if the tenant says no, it's just a non-starter at that point. But practically speaking, that's kind of the case anyway. Because if you're dealing with a tenant who says, no, I don't want people coming in, I don't feel safe, maybe the tenant's elderly or immunocompromised, or maybe they're just difficult, but whatever the reason may be, once someone says, I don't feel safe, don't come in, from a risk management perspective, it is beyond risky to try to force the issue and force your way into the property. It's just, I would never advise it. And it's, again, a conversation to have with a seller if you're selling tenant occupied property about how are we going to work this out. We may need to negotiate with this tenant to resolve this issue, because if the tenant says, no, don't come in, I just, like I said, I would never advise forcing it. I think you basically have to respect that. Again, especially now. In normal circumstances, if you had a tenant who was being difficult and non-cooperative with showings, you could give them a 3-day notice for breach of terms of their lease. The law and the lease requires a tenant to cooperate with showings, but now's not normal circumstances. And like I was saying, even if you could give them a 3-day notice, you can't evict them anyway. So it's a tough situation with honestly no good answers. It comes back to the same advice of negotiate with a tenant, try to work something out, or talk to the seller about other options, because it puts you in a very difficult place.
That's a tough one. One question actually that came in, I've of all the times that we've been doing this, I haven't seen this question. Can we require the showing agent to clean before and after their show?
You know, it's a good question, actually. That is one of the things we've sort of been discussing as a group among the attorneys is, you know, could you arguably shift that responsibility? I mean, they're a licensee, they have to follow the showing guidelines. And basically a seller can, within reason, set whatever rules they want for a showing. So could a listing agent in cooperation with a seller say, we are only going to allow showings where the buyer's broker agrees to come in and clean before and after they show the property? I think arguably so. The seller has a lot of leeway to set what rules they want for their property to be shown. Now, if something goes wrong and the property isn't sufficiently cleaned, can you just sort of throw up your hands as a listing agent and say, not my responsibility, I told the buyer's broker to handle it? That's where it gets a little bit less clear in terms of where the ultimate legal responsibility will fall. I think if the worst case scenario were to happen, there'd be plenty of finger pointing and blame to go around anyway. But as a practical matter, yeah, a seller could have that as their policy for having the property shown.
Okay, let me just make a statement here because I know you've got a little bit more to do before we can go back to more questions. There have been dozens of questions, if not more than that, and I haven't been able to get to them all. I think that you've answered most of them already. The cleaning guidelines you guys are going to put out next week will be a huge help.
Yes.
But if there's still something that hasn't been asked or answered, I'm sorry, that you asked earlier, please put it in the chat box again so we can come back, because it's really tough to scroll back all the way up there and sort through those. And pay attention to your presentation as well. So
sure.
If you can help me out, that would be great. So
sure.
Go ahead and finish up, Jana.
Yeah, all right. So yeah, there's just two more really important things that I want to talk about, and then we can just sort of go to questions for however much time we have left. I was talking about this industry guidance. Mostly we were focusing just now on the cleaning rules, but there's some other really important rules that have to do with showing properties. And you'll see on here, what this new statewide showing guidelines, industry guidance requires is that agents establish a written COVID-19 prevention plan to be followed by agents who show properties, to display a set of rules for agents and home viewers at the entrance of the property that are to be a condition of entry. I'll show you how that's going to work in a second, which is basically for now a combination of the PEAD and a new form that just went out this morning. The posted rules need to be clearly visible and have to include pictograms, images basically for anyone coming in the property who may, I presume, either not be able to read or more likely not be able to read English. And then brokers are required to regularly evaluate compliance with the plan and document and correct any issues that are identified. So this is going to be an ongoing process. And there's two things mentioned on here that give you extra work, which is establishing a written prevention plan and displaying these posted rules. So, like I said, we're working on a sort of comprehensive set of documents for you all, but in the meantime, we do have a sample prevention plan and rules you can post, including some very nice looking pictograms. And that is this new form. It went out this morning. So hopefully if you got an email from carnews@car.org this morning, it was sending out information and a link to this form, which basically lays out in visual form what the rules are for seeing a property. And it basically lines up with the PEAD, but this is something that needs to be posted outside of all properties that have to be shown. I know it's fairly intimidating looking, and I can already imagine people thinking, it looks like something you'd see out of a biohazard facility, but that's what the rules are right now if a property is going to be made available to be shown. So it basically says the rules: wear a mask, wear gloves, wash your hands, practice social distancing 6 feet apart, do not touch surfaces, and discard gloves or any disposable masks or anything like that upon exit. And then also tell someone, if you are ill or have been exposed within 14 days, please do not enter the property. Only come in if you can say that that's the case. So we're working on a sort of one form that will have this and will have all of the rules as well in writing. But for this weekend, basically, if you are going to be having a property and showing properties today and through the weekend, the advice is to have this form posted and have a copy of the PEAD form posted side by side. Those are your showing rules that will keep you in compliance with the the California Public Health showing guidelines. And the one other thing I briefly wanted to mention, it talked about establishing a written prevention plan. That's required for both showing properties and for opening up any work sites. If you have agents coming into an office, you have to have a worksite specific prevention plan, and CAR has created that as well. It's also linked on that COVID legal docs page, and basically to give you a starting place to have these written plans, because they're extremely burdensome. They require risk assessments and putting people in charge and identifying issues and taking precautions, and it's all in there. And so if you are going to be opening up a workplace, we have a sample plan for that. And like I said, this is all, we're scrambling. We get this information and we react as fast as we can to get you the documents you need. But hopefully, very, very beginning of next week, you will see a big release with a sort of comprehensive prevention plan, showing guidelines, revised best practices. We're getting that to you as quickly as possible. So those are the other main things I wanted to talk about, and I'm happy to sort of take whatever other questions have come in.
This pictogram obviously created a lot of questions coming in.
Yeah, I saw the screen start flashing at me.
Where is this thing supposed to be discarded? This doesn't say booties, which is great, but
Right.
I know that everything's a work in progress and we're trying to get
Right.
back to things, and I understand that, and guidelines will be changing daily, but this is what we're supposed to use right now. But
Right.
where are we supposed to dispose of those things?
Right. No, it's a great question. There's no requirement that you provide a place to discard them. Really, it's advising the people who came through the property to dispose of them. I think they can probably dispose of them themselves, wherever they're going to. But that, again, work in progress. That's my current interpretation. I wouldn't be surprised if there ends up being advice to have a trash bin available near the entrance or exit to dispose of items as you come and go. Not specifically required in the rules. Literally, this is one of those what you see is what you get as far as the guidance. People should be advised to dispose of the items. They didn't say how. So again, it's evolving. Like I said, my personal opinion is that you could just tell the people you need to discard of those items. Really what we want to prevent is people just dropping them and leaving them in the property. So they're being advised to dispose of them on their own. Or if you are worried about people behaving responsibly, you could put a bin by the door saying dispose of items here. It may depend on just how it works practically.
Another question about two things: home inspections, about touching, how that works. And then this is an interesting question. If we were showing a property and we bring wipes, we bring something to the property to clean up after, and what if that causes damage to the property, the paint or the surface? I know.
No, these are excellent questions. They really are. As far as inspections and things, I will say these guidelines really are for showings. So inspectors and contractors, they're going to be a little bit different. They should still be wearing masks. They're the ones who I would say the most important, they're wearing gloves, because to do their job, which they are allowed to do, they may need to touch things, and that's fine. But masks and gloves still, and frequent hand washing. The do not touch surfaces is really the advice for buyers and buyers agents coming through the property to not just be unnecessarily touching things. So that's question one. Question two about the wipes and damages. Great question. That maybe is a reason for the seller not to just tell the buyer and buyer's agent to do it themselves, because what happens if they do damage something? I mean, these are the kinds of questions that, I mean, no one's asked me that yet. I've been answering questions about showing properties in this situation for a couple of months now, and that's the first time that's come up. And I think it's a great question and probably a, again, discussion to have with a seller. I will say the purchase contract, for example, does have language in it just all the time that if a buyer or their agent or an inspector or anybody they bring into the property damages the property, buyers are responsible for it. Now that language comes from the purchase contract, so that would really mostly apply not before you're in contract, but if damage was done during the escrow period, that's always there. Buyers are always responsible if they damage the property. But showings are always a little bit trickier about whose responsibility that is. And it's a good reason to be concerned on all sides about having anyone other than the seller, or maybe, you know, I guess what I'm saying is if I were a seller, I would be motivated to maybe make sure that I was purchasing or approving whatever was going to be touching surfaces in my property to try to limit this from happening. But again, it's a great question, and thankfully I haven't heard of that happening yet, but it does seem a little inevitable.
Well, and it's really interesting because, you know, when we look on standard forms, sometimes we spend months wordsmithing a paragraph, a word, right, before the form's released, because there's so many ways it can be interpreted. And even then, when it comes out after all that review, someone says, well, what about this? And we end up changing it. So there's no way to cover every possible scenario. Things are changing daily, if not hourly. And so we're giving the best information we can today. We always have to stay on top of this to make sure that it's current with the forms and these things. And I'm sure this will be changed as well at some point.
Absolutely. Yeah, I think that's a great point. And it's that times a million when it comes to these rules and guidelines coming from the state too, because they're just throwing them out there. And a lot of times it's being written by people who aren't that familiar with the specifics of the real estate industry. So that's why we're trying to give them feedback to say, wait. Yeah, so it's, it's a lot to sort of process all at once. But yeah, I mean, this is all this information we have as of today. You know, the CAR website, I know CAR sends a lot of emails, you know, we all get them too. But really now is actually, I always say to read them, but now for real, all the emails we're sending tend to have extremely important, relevant information. Please check them out. Please read them, even though I know you get a million of them. And the website, that legal docs page and the carcovidupdates.org, that's updated usually multiple times a day with whatever new information comes out. That's the best way to make sure you're getting the most current information.
And when all else fails, can you give us the legal hotline telephone number, please?
Absolutely, I would love to. So you can also always call the hotline. We are open Monday to Friday, 9 to 6, and for transactional questions on Saturday from 10 to 2. That number is 213-739-8282. And I always tell people, you don't have to wait until there's a problem to call us. You know, you can call just sort of thinking ahead. That's probably the best time to call. No question is too silly, especially right now.
Okay. I think, well, there's some that we're not going to get to. There's just no way. We're running out of time here. We're right at 11 o'clock. Again, this whole presentation will be recorded, or is being recorded. It will be available hopefully tomorrow at nsdcartv.com. Go there. You'll be able to review this again. And gosh, I think that's it. We will post the CR hotline number, legal hotline number, in the chat. And thank you again, Jana, for your time. It was a great presentation.
Thank you so much for having me. Sorry we couldn't get to all the questions. I know there's a lot going on right now, but yeah, hopefully I can come back sometime, and you can always reach me on the legal hotline.
And we are taking a break next week. We will be back in 2 weeks with a broker panel on how they're handling it, from some big businesses, big companies, small companies, how they're dealing with all this stuff. And one of the things that Jana said, which is really important, the information is changing so quickly. Go to that website, go to cr.org, go to the COVID section, and whatever's posted there is the newest, most up-to-date information. Check that out constantly. Make sure that you're using zip forms, because the most current form will be there. And until then, thank you guys. Stay safe, be well. Thanks, Jana.
Thank you. Bye, everyone.